state of Florida really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year, or over a year, with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Devins, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not, that has been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation. Because a year ago, we would have sat with Mr. Devens, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Devens' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Devens' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Ms. Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case, not sure the rest of the defense team can try the case, and don't know, and a prejudice to Mr. Devens would be monumental that at this late stage you'd have to get a whole new defense team. So we need these questions answered. It's not just as simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state wait for this matter to be over. We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Devens, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Ms. Liberty has not been allowed to see Mr. Devens in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Devens on the other side of the glass partition by phone. Have they been tapped? Have they been listened to? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Devens and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Ms. Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Devens' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Devens has a lot of thinking to do. Hopefully the court will give us a hearing if some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decision.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want answers? Because I didn't find any authority. I don't even know how I would do that, by the way. But
Well,
do you have any authority? I understand you're saying, that's the judge, this is what we like. I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant? How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you, I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question, the Shanner investigation. And the answer is yes. So the only other question that Rutledge requires is that Mr. Demmons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well,
Right.
then I will file another motion for prosecutorial misconduct and ask for a hearing on that. And subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well, let's-
criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demmons now has been informed that Ms. Liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demmons needs to know these before, quite candidly, he can make that choice. Now, he can say right now that he wants Ms. Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Ms. Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today?
I don't think we can.
When would you like me to reset?
I do not know how long it will take. Ms. Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight and flew to Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Ms. Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30, but I do think it takes some time for us to talk to Mr. Demmons. She certainly needs to talk to Mr. Demmons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, quite candidly. And we need, if I may,
Yes, sir.
we need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabonis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called tank team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know that the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
And
that's all I
has anyone
have.
said anything that this has anything to do with Mr. Demings?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Demings?
It does, John.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demings make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. We can't give anything over until it's
Well,
officially completed.
With all due respect, but this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right?
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll speak with my office and you can have a week to figure this out.
Judge, they've had since December of '23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? Defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demings has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we would file any sort of motion to prevent the search warrant from being handed over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two, at
You
minimum.
can decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't, under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devens. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant?
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so, but maybe it's something so de minimis that Mr. Devens is gonna say, that's fine. If there's any conflict, I'll waive it, and, let's get to work. Or if not, I guess he's gonna have to go find 5 other lawyers to do this, who are gonna be ready to try a capital case in 9 months, so. How about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
And again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we would get a ruling. The problem is, the stay that was issued by your previous judge, we cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering, because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there is a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, your example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up, because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of be a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I did not look at that motion.
Okay, so why don't we do it this way, all right? He's gonna remain on the docket tomorrow. I have a few other matters on both FX and MT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for some of these
you're gonna
titles.
go to trial in September. All right. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do, so.
Assuming we're still on the case. And that's a big assumption at this moment.
And Judge, we're still asking for proper notice of what we're actually going
I
to
did,
hear.
well, I'll take the blame for that. All pending motions. That's why I put that down to the end tomorrow. All pending motions. They're asking for I believe, they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title, she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today? Okay, so the FX and FT are both going to otherwise be recessed until tomorrow, which is?
Excuse me.
Yep, yes, sir.
I've been told that Mr. Demons has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT will be in recess until then at 8:45 a.m. I hope you all have a good rest of
Thank
your
you.
morning. All right, Mr. Court Reporter, that is it.